Start. Several retired judges, bureaucrats, and armed forces veterans have released a statement seeking recall of the remarks made by a Supreme Court bench on the Nupur Sharma case. In the meantime, Justice J.B. Pardiwala, one of the judges of the vacation bench which dealt with the Nupur Sharma case, warned that agenda-driven campaigns through social media are adversely impacting matters relating to law and constitution. As per the SC judge, constructive and critical appraisals of the judgments are permitted in democracy, but personalized attacks on judges are harming the judicial institutions and lowering their dignity. He emphasized the need for the law to stop interference in the judicial proceedings. Four important elements of this controversy need to be examined as per the constitutional provisions and apex court judgments para. The Constitution of India gives immense power as well as places onerous responsibilities on the Supreme Court. Open court proceedings ensure that the judiciary is subject to public scrutiny. Judges are expected to act in accordance with law and also exercise caution while making observations in open courts which may be susceptible to misinterpretation. Para. While dismissing the petition of suspended BJP spokesperson Nupur Sharma, the Supreme Court bench said that her remarks set the country on fire and she was a threat to the security of the nation. The judges may be right in observing that leaders often resort to controversies to advance their political or nefarious agendas. At the same time, judicial restraint should be exercised while using strong language to criticize any individual or institution. These remarks are also criticized on the ground that it is not reflected in the final two-line order para. Justice D.Y. Chandra in the Election Commission of India judgment stated within double quote language both on the bench and in judgments must comport with judicial propriety. Judicial language is a window to a conscience sensitive to the constitutional ethos. Bereft of its understated balance, language risks losing its symbolism as a protector of human dignity. Quotation close. Those who are criticizing oral remarks are of the view that blaming Nupur's comments could be seen as judicial approval for the violent protests, arson, and gruesome murder of a tailor in Rajasthan. Despite no judicial value, critics add these observations can be further used for mobilizing the radical and terror impulse para. Nupur Sharma has made derogatory remarks about the Prophet, but later she issued an apology and withdrew her statements. Her supporters are justifying the remarks on the ground that it was in response to objectionable remarks by the rival panelists in a TV debate. Despite that, several FIRs were registered against her in many states. Her petition seeking a transfer of all cases to a court in Delhi was dismissed by the Supreme Court with many oral remarks para. In a judgment delivered in 2001, the Supreme Court held that there cannot be a second FIR on the same issue. The apex court in the case of Arnab Goswami in 2020 expanded this ruling and said that similar FIRs in different police stations on the same ground against the same person also violate the fundamental rights of a person. Many such judgments were binding on the Supreme Court bench hearing the Nupur Sharma petition. The bench, however, dismissed the petition with strong oral remarks. Oral remarks are not part of the official judicial record and therefore the question of expunging them does not arise. However, a review application can still be explored by Nupur Sharma with a prayer of clubbing all FIRs in different states in the same matter. Stop.